All right. Thank you so much to everybody who has joined in. I have a few announcements while the rest of the participants are getting joined for today, but thanks to everybody who's here. Um, Today we are doing our second webinar for the Emergency Response Program. And as always, we want to thank our supporters and partners in this program. So the Indiana Economic Development Corporation, Gutwein Law, who's here to speak today, and then M Accounting and the Weber Co. Thanks again to all of our partners. We really appreciate your support. A couple of housekeeping notes for today. Everyone should have received information to get dialed in when you join the Zoom, but if not, let us know. If you have questions during the webinar, you can ask questions via the Q&A box on the webinar screen. You can type in your questions and send them, and then we will go through those questions and read them out loud at the end after Karen is done with her presentation. You can also go in and upvote other people's questions. So if you feel that somebody already asked a question that you think is super important to get an answer to, you can indicate that with an upvote. If we have any unanswered questions, we will do our best to answer those after the webinar. So please make sure that you do not send your questions anonymously so that we can follow up with you after the webinar to make sure that those questions are answered. You can also send emails to cole@generator.com during the webinar if you have questions and are having trouble with the Q&A feature. Next, we wanted to just address technology issues. If you are having trouble or having technical difficulties, unfortunately, due to the number of participants, we are not able to help solve technical issues. You are always welcome to reach out directly to Zoom if you do have any trouble or need technical assistance. We will also be recording the webinar and we'll share it with all registered participants. So if you miss it or if something happens and you miss a section, we will share it afterwards so that you can listen to the recording. Okay, so without further ado, I'm going to turn it over to Karen Young, who's a business law attorney with our partners Gutwein Law, and she will be talking to you guys today about navigating the new employment law.
Great, thank you, Chelsea.
Hold on, we're gonna stop sharing and then you should be able to share your screen if you would like to do so.
I'm going to share one thing with participants now.
Awesome.
And to help with the technology issues, if anyone is worried about their internet connectivity at this time, which I can fully appreciate, or would like to not look at this on Zoom, you can go to our website here and download the slides that I'm going to go through. Maybe I moved too slow or too fast for you. They're right there. And again, they'll be part of the presentation that Chelsea will share afterwards. But if anyone wants to look at the website right now and see the slides as we go, you can download those right now on Gutwein Law's website. All right, you should see the slides now.
Yep, we're all set.
Great. I want to talk a little bit about Gutwein Law, not very much, but we're a smallish law firm in Indiana. We have offices in Indianapolis, Lafayette, and Evansville. So we're prepared to work with clients throughout the state. We cover all things business. And today we're obviously covering issues that relate to employers from the employer perspective. And we have several attorneys working on a lot of issues right now for our clients, and law firms across the country are very busy working and getting up to speed on these issues. So I'm very happy to be speaking with you about these very timely issues that are out there today. There are a couple of polling questions on the site. I'd ask that you go ahead and answer those if you haven't already. Chelsea's sending me the updates because I want to be sure that I know who my audience is and can fashion it and what we're going to talk about accordingly. And maybe from some of your questions, I'll pick that up. But again, my name is Karen Young, and we'll get started. Just as a disclaimer, these issues are changing and evolving so quickly. So any of the information that we're presenting here is going to be overview and general advice and guidance on what we've researched and studied, but anything that you may not want to share right now, want to share off to the side, individual situations that you're going through, there may be some personalized advice that needs to be considered, and speaking with your attorney or with us on those issues. It would be personalized and needs to consider the circumstances. So just want to put that out there, that this is general, broad guidance as opposed to for your specific company and exact situation. Here's what we're going to cover today. We're going to cover, a lot of folks have been doing furloughs. I think about 25% of you have already either laid off or furloughed employees. That is definitely the thing we started hearing from clients on the first wave of issues were canceled events, closed college campuses, and our clients that had any services or operations dealing with those issues. So furloughing and laying off employees about 9 days ago were the first things we were hearing about. And then that triggers potentially the WARN Act and notices that need to be given. So we're going to cover that. And then we'll jump into the COVID-19 specific acts that have been passed, the Families First Coronavirus Response Act with the 2 leaves, Emergency Paid Sick Leave and Emergency Family and Medical Leave Expansion Act. I'm going to throw in a couple other considerations that are a little outside of the scope of employment law, but I hope that businesses will already start thinking about now as they move through this crisis. So as far as your employees, I just want to set the stage that under OSHA and state laws, employers have a general duty, which is a high duty to your employees, to provide a safe workplace. And so there's been a lot of need for communications, both internally and externally, to all of your stakeholders of when should employees come to work or not come to work. Can I lay an employee off? Can I take an employee's temperature? Can I send someone home, paid or unpaid? All of those issues we've been struggling with employers and trying to grapple with that, as well as letting your external partners know we now have changed work hours. People are working from home. We're not going to have in-person meetings. Don't come to our office, or do come to our office. Stay in your car. We'll come to you. All of the changes that are happening. You have some things you need to think about. Privacy and HIPAA considerations prohibit you from listing a person's name. So if my law firm, if I was diagnosed as potentially exposed or having coronavirus, I would hate for my employers to send that a firm-wide email saying, Karen Young has coronavirus, stay away from her. That's going to violate my HIPAA protection. So there are things like that that you need to consider as you're rolling out communications internally and externally at your companies. And then I'm sure that folks are going remote. I'm actually in my office today, but this is the first time I've been in the office for at least 10 days. So remote working policies, banning or limiting travel, limiting visitors into your office, rolling all of those policies out. The EEOC and ADA are actually loosening constraints for employers and actually allowing employers to ask questions that you wouldn't typically be allowed to ask, and maybe taking an employee's temperature day upon day. There are considerations for how you keep track of that and how you talk to an employee. If you're going to ask them those questions, that needs to be in a private setting, but you can ask it because of the public safety issue that has arisen with this crisis. So things are rapidly changing and evolving and allowing employers to do things they wouldn't have otherwise been able and in compliance to do. And then we'll speak about employee furloughs and layoffs. And again, I encourage you, if you're just joining, to go ahead and answer the questions on the Zoom poll about what size your company is and if you've done any employee layoffs or furloughs yet. A forced furlough, the wording that's used is a mandatory required leave without pay. Benefits usually are not impacted, general health benefits, health insurance, etc. But the main point here is that exempt and non-exempt employees cannot be treated the same exempt employees considered salaried. If an exempt employee is put on furlough without pay and he or she works at all during a week of furlough, that employee can demand payment for the entire week. So employers need to be very careful in communicating both to the employees and to that are on furlough and employees that are not on furlough, especially if they're exempt, not to work with them, reach out to them, have them check emails, things like that. You need to be very careful if you're furloughing exempt employees. For non-exempt employees, it's more simple. Hourly employees, for the most part, they're just paid for each hour that they work. So if a non-exempt employee, an hourly employee works any portion of a furlough week, they are simply paid for the hours they're working. So it's much easier to manage that versus your exempt employees that are guaranteed that salary. So be very careful when rolling out a furlough, how you treat those two different categories of employee. Depending on the size of your company, if you intend to do a mass layoff, and we'll define that in a minute, you have obligations under the Federal WARN Act. Indiana follows the Federal WARN Act and doesn't have a separate state enacted WARN Act like some other states do. So in Indiana, we're speaking just about Indiana law today. In Indiana, Indiana adheres to the Federal WARN Act, and if employers have 100 or more employees, when you carry out a mass layoff, you must provide a 60-day notice unless there's unforeseeable business circumstances. I've already drafted a WARN notice for a client, and we have not given that required notice because we consider a global pandemic that shut down operations for this client overnight is an unforeseeable business circumstance. The WARN Act notices are public documents. You can log on to the Department of Workforce Development and see all of the employers in our state that have started laying off either temporarily or permanently employees that are companies of over 100 employees in our state. And that's already starting to happen in mass. And you can see other folks' notification letters that were sent out and what's happening, what's going to be happening. And the Department of Workforce Development is updating and keeping their website open. They want employers to reach out to them in advance and proactively to make getting those employees onto unemployment more quickly and more smoothly. So the burden of that 60-day notice requirement, whether or not you can hit the 60-day notice, you still have to give notice, and you have to notify the Indiana Department of Workforce Development and their dislocated worker unit if you intend to do a layoff. And a mass layoff, let's go to the next slide. A mass layoff is generally, look at this bold portion, at least 33% of active employees excluding part-time, and at least 50 employees excluding part-time. So you have to do some calculations with your workforce of whether or not you hit how many folks you're laying off, and if you hit these thresholds in order to require a WARN Act notice to be given. So I'm going to jump in.
A question.
Sure.
One of my employees filed for unemployment while working 25 to 40 hours per week. How do I respond?
That is a great question. Here you go. The answers are here. Employment benefits have been expanded, and the Department of Workforce Development, I'm going to jump ahead a slide to answer this question as well. You'll see here the second bullet point. When you go to the Indiana Department of Labor site, it actually is instructing employers to encourage your employees to file for unemployment benefits now. So when that person, one of your persons filed for unemployment, encourage that. Eligible workers are receiving an additional 13 weeks of unemployment benefits. Most states would have only allowed 26 weeks. And so employees are now allowed 39 weeks. If someone is already receiving unemployment benefits unrelated to the coronavirus, they get their unemployment benefits extended for 13 weeks, and they get that additional $600 weekly benefit from the federal government. I'm not going to talk about the $1,200 going every which way. There's a lot of rules around that. I won't get that, for instance, because I can still telework. So there's a lot of rules and restrictions on who's going to get those checks in a few weeks, but for those on unemployment, they'll get an extra $600 weekly benefit as part of that stimulus package. That will last for 4 months, going through July 31st. States are incentivized to waive that waiting period for unemployment. It still might take a while because there's just so many unemployment claims right now, even in our state. And so the process may still take a while, even if Indiana waives that 1 week waiting period. But generally speaking, like I show on the next slide, the Indiana Department of Labor is encouraging employers to tell their employees to file unemployment as soon as they're laid off. There are very few in-person sites that your employees can go to, so they're encouraged to file online and even at your offices. If you're going to do any kind of layoff or furlough, even if you anticipate it to be temporary, if you can help folks file for unemployment at your office, that's being encouraged. If your company has a shutdown or operations and lays off employees, unemployment insurance is available, but the types of leave we're about to speak about, they won't be available to an employer and their employees if you have laid off employees or shut down operations. You can maybe reduce hours, but you have to actively be open and operating in order to give the other two types of leave that are allowed under the Families First Coronavirus Relief Act. You have to be operational and up and running in order to get this kind of leave for your employees. I'll tell you, when you download the PDF of our slides, these links are live and you can click right to the links I'm citing. And we did that because, again, they're constantly being updated and changed and trying to serve employees and employers better and more quickly. And so I encourage you to go to the websites and get the most recent guidance to keep up with the speed of business. I see some of the different questions coming in. From what I'm seeing, as far as people working reduced hours or I call it underemployed, we are seeing in the next wave of the stimulus package, this CARES Act that's coming out, guidance should be available by the end of this week. I do believe that the government's going to catch up with the concept of underemployment and fill in the gap. Or you can also potentially apply for a Paycheck Protection Program loan. That was passed, again, late Friday, the CARES Act was passed. We're expecting by the end of this week to have more information on how employers can file for that Paycheck Protection Program. Employees have to stay actively employed and not laid off or furloughed during that time, but you can bring them back if you've already furloughed them. I don't want to get off track there. The guidance is not out, but be watching for that. You can go to our website. We'll be giving updates and guidance and recommendations on how to follow that process. And so you're going to start hearing more about that. So for those of you, many of you who have not yet laid off or furloughed employees, if they cannot do work and you need to lay them off or reduce their hours, the Payroll Protection Act is going to come in as payroll forgiveness, and it's a loan that you'll get that will be forgiven. They want it to be, the government wants it to be a grant. I was on a call with the folks from the SBA in DC saying they want it to be a forgiven loan that won't be ongoing, and basically pay your employees for 8 weeks and then forgive that loan so you're ready to get up and going when this passes. And it really is just paying your employees to stay on your employment role, regardless of whether they have work to do or not, so that they don't file for unemployment. Those unemployment numbers don't go sky high, but you'll have a forgiven loan to make your payroll, basically paying your employees not to work because there's nothing to do, but keeping them on your payroll and keeping them paid, forgiving you the debt or the loan that covers that place. So that's the Payroll Protection Program under the CARES Act. Again, guidance to be given by later this week. You cannot yet apply for that loan. The applications are not yet out. Is there a timetable for the extra payments? I think I saw 3 weeks. They're expecting, now that the bill passed on Friday, within 3 weeks, those checks are supposed to be coming. And I would encourage anyone who has employees taking reduced hours to apply for unemployment for that gap. I would. And then if it ends up that you get a payroll protection loan and there's a double dipping, that'll have to get sorted out. Either it comes out, the employee stops unemployment, or there's an overlap and something has to be redone. And so when you go to get your loan forgiven, maybe that has to be paid back out because an employee got double paid or something. There's going to be some hiccups and overlaps of these benefits that'll have to be shaken out. All right, I think that's all the questions that are coming up live, and I'll try and address those as they come so we can stay on the topic that they're talking about. So for the Families First Coronavirus Response Act, this was the first act that came down. I'm going to go to my slide. Yeah, it was signed March 18th. It becomes effective tomorrow. The two most important pieces that we're going to talk about in this act that affect employers are the Emergency Paid Sick Leave Act and the Emergency Family and Medical Leave Expansion Act. These acts apply to employers with fewer than 500 employees, so almost all private employers will be covered. Healthcare providers and emergency responders can be excluded. For instance, doctors can't take medical leave right now. We need them at the hospital, so they're accepted from complying with this. What I find so interesting about this act is that typically all of you on the call today, most of you on the call today, do not have to comply with Family Medical Leave Act policies right now because you don't have enough employees. I work for a company that doesn't have enough employees for FMLA leave to be available. So the Emergency Family and Medical Leave Expansion Act gives and expands the number of employers that this applies to, and it's in a very specific instance that we'll talk about. And the same for Emergency Paid Sick Leave Act. It applies to all employers with fewer than 500 employees. So let's jump into this first one. The Emergency Paid Sick Leave Act becomes effective tomorrow. All employees, no matter how long they have worked for you, can apply for this leave. It is paid. You cannot require your employees to use PTO or accrued vacation time or anything first. They can opt for that, but you can't require that. The good news is this last point, that the Department of Labor will not bring enforcement actions in the first 30 days of enactment of this, so long as you're acting in good faith and can show that you've taken reasonable efforts to work with your employees who need to go on leave and trying to do right by them. I think that's great. That, to me, as an attorney, lowers the risk for employers taking steps or actions or interpreting the very new law in a certain way. I think the risk is being lowered for employers who are trying to do the right thing, not getting their hands slapped with an enforcement action. So who is eligible for the leave? I have to move my pictures out of the way a little bit over here. If the employee is subject to a federal, state, or local quarantine or isolation related to COVID-19, I'm not going to read all of these, but I'm going to read this first one specifically. It really sounds like every employee could print off something that Governor Holcomb said, take it into their employer, and get leave, paid leave for 2 weeks. That's not the case. The guidance that's been given by the Department of Labor shows that that must be a personal healthcare provider or someone that actually tells you, your employee, and they have something from their healthcare provider that says they have to be quarantined or isolated. This is not a broad stroke. So this does not just apply because Governor Holcomb has told us to hunker down. They print off a press release. That's not enough. If someone has been advised by a healthcare provider, is experiencing symptoms, is caring for someone who does have symptoms or needs to be isolated, or if their son or daughter's school or childcare location is closed, and then someone experiencing any other substantially similar condition as those are updated. So this is very specific. If an employee falls under one of these 6 categories, they're eligible for this leave. How long do they get it, and how much money do you pay them? It depends on if they're full-time or part-time. If they're full-time, they can get 80 hours of paid leave. And if they're part-time, you average their hours that they typically work over a 2-week period. I would look back 6 months. What's their average 2-week period? How much do they get during that leave? Depends on the previous slide. The first 3 reasons, look at the column on the left of the screen. They get their regular rate of compensation, not to exceed the 5,110. If it's reasons 4 through 6, they get 2/3 of their pay, not to exceed 2,000. Okay? It's very specific. This is detailed in all of the regs and all of the guidance that's put out there. What records do you need to keep to verify your paid leave because it's reimbursable? We're going to get to that. So what you need to keep as an employer is documentation from the employee with all of these details, the reason why, and you need to keep it to claim your tax credit. So if you don't yet have a process in your payroll or HR department to track medical leave or paid leave off, you have to implement that now. And so then you can document both with hard copy documents or whatever the employee provides and your payroll numbers to get the tax credit. The tax credits are available for both of these types of leave, so we'll get to that in a minute. The question on a nonprofit, I believe this applies to nonprofits as well, just less than 500 employees. The same thing applies. You won't have the need for the tax credit. I'll have to look into that one. The nonprofit receiving this, because you get the benefit through a tax credit, so it has to work a little bit differently. It definitely does apply, however, for nonprofits. So let me look into that question. The next part is the Emergency Family Medical Leave Expansion Act, a mouthful. I'm going to back up and talk about regular FMLA that existed before tomorrow and this expanded FMLA. Typical Family Medical Leave Act that's still in place applies to employers with 50 or more employees. So that's why my polling question was whether you're over 50 employees or not. If you are over 50 employees, you should already have an FMLA policy in place. And this is just an amendment to your policy that gives this expanded leave. If for employers that have 50 or more employees, an employee to be eligible for FMLA leave had to work for you for 12 months. So that's under what was FMLA as we've known it up to today. As of tomorrow, due to the public health emergency of COVID-19, this Expansion Act applies this one narrow expanded portion of FMLA leave to apply to all employers with fewer than 500 employees. So for those of you on the phone today, if you've never been subject to FMLA before, you will be, as of tomorrow, subject to EFMLEA. So because it's expanded to employers with fewer than 500 employees, almost all private employers will be covered. And it applies to all employees who have worked for you for at least 30 days, which is vastly different than the 12 months that typical FMLA falls under. So if you have fewer than 500 employees and any employee needs to take this specific leave that's worked for you for 30 days or more, they're eligible to take this leave. What is it? It applies to working parents. This is very narrowly tailored. It's broadly applied to all employers, but it is only eligible, the only employees that are eligible have worked for you for 30 days or more, and they have a qualifying need that they are unable to work or telework because their son or daughter can't go to school or childcare. So this expanded FMLA only applies to your employees that are working parents whose children can't go to childcare or school. So it's broadly expanded, but for a very narrow pool of your employees. It comes into effect tomorrow. The first 10 days of EFMLEA can be unpaid or are to be unpaid. you will not be reimbursed for the first 10 days of someone's leave, is what I'm telling you for employers. The employee may elect to use their PTO time, just like the former leave that we talked about, but you cannot require them to do that. They can take PTO to cover those first 10 days, but they're not required to. How long does this last? Like typical FMLA, EFMLEA leave is 12 weeks long. So they would take the 12 weeks sometime between April 1st and December 31st. But let me also clarify, this does not extend an employee's entitlement to FMLA leave overall. Meaning, if you're an employer that is subject to FMLA, this does not give employees 24 weeks of leave. If you had an employee who has already exhausted some or all of their 12 weeks of FMLA, they don't also get these 12 weeks. If they've used 6 of their FMLA, then they'll have 6 available for EFMLEA. This does not translate into any given employee receiving 24 weeks of leave for you employers that are over 50 employees. I see the question of how does this apply to part-time? It does. Employees that have a set schedule, this is how you determine how much you pay them. After those first 10 days, pay is to be no less than 2/3 of the employee's regular rate of pay, but not to exceed $200 per day or $10,000 in the aggregate. If you have employees that have a varied schedule, or they haven't worked for you long enough for you to make up an average of how much they work, or maybe any 2-week period, they work vastly different amounts of time, this is the way you calculate how much they're to be paid. Again, after those first 10 days of unpaid, you calculate the average number the employee works per day over the prior 6-month period and come up with that. Or if they've not worked for that 6-month period, you follow a reasonable expectation of the average number of hours per day that employee would be expected to work when you hired them. So again, take a reasonable approach, average number of hours, 6-month look back. Again, this is employees that are working parents, their children's childcare or school is closed, they've worked for you for more than 30 days. That's this 12 weeks. I don't have it on the slides here, but there is guidance on intermittent leave. So let's say, for example, I have 3 children. I do have 3 children. Their schools are closed. My husband and I share the burden. So I'm going to only need to take half days where I can't work because I'm going to be with my kids for half days. So I could take 12 weeks of half day time and only use 6 weeks of the leave because I'm only using it intermittently or part-time each of those weeks. The same thing with maybe I work Tuesdays and Thursdays. So I'm taking 2 or 3/5 of the time. There's definitely guidance that is out there that we have on our website that specifically answers from the Department of Labor how you handle each of these different scenarios. There's a question here, can the employee who has taken care of children because of daycare closing use the 6 paid leave for the first 10 days and then go right into family leave? Yes, they can. That guidance is very clearly shared from the Department of Labor. So if someone needs to take the extended FMLEA for the first 10 days, they can take that emergency paid sick leave. That is paid. They can do that. Like FMLA, the FMLA typical act, having an employee gone for 12 weeks is a substantial amount of time, especially on a small business. So for FMLA, an employee had to work for you for 12 months and being an ingrained person. And then for those 12 weeks, you had to make do without them and hold their job. They had to be able to come back and return to the same or equivalent position with equivalent pay, benefits, terms, etc. That applies to EFMLEA. When your employee returns from leave, you have to return that employee to the same or an equivalent position with equivalent pay and benefits. There is one exception for employers of less than 25 employees. I'm throwing a lot of numbers around, I know. For an employer less than 25 employees, if the employee's position does not exist because of economic conditions caused by this emergency of COVID-19, and the employer has made reasonable efforts to bring that employee on leave into another equivalent position, then that employer does not have to retain that employee who was on leave. So there's a very specific and narrow exception for small employers of less than 25 people not bringing someone back after they've taken leave. However, for the coming year, after you've terminated them because their position has been eliminated due to COVID-19 emergency, for the coming year, you're obligated to use reasonable efforts to contact the employee and ask that employee to come back if a equivalent position should become available. So there's definitely strings attached to this exception, but in general, any type of FMLA leave is a job protected requirement. And this is a very different expansion of this act that's going to apply to everyone, and that's new. The EFMLEA, does it vary depend on exempt versus non-exempt? I take you back to the slide right before here. Basically, employees with a set schedule are going to be the exempt employees. And then employees with a varied schedule, non-exempt. So you just work out their pay. How to get reimbursed. So the 2 weeks of paid, emergency paid leave, sick leave act, I misspelled that. And then this expanded FMLA reimbursement. The tax credits and advancements are available through December 31st. For complete coverage, you get complete reimbursement for healthcare. Employers don't face payroll tax. This also applies to self-employed individuals, and reimbursement should be quick and easy to obtain. I know you're laughing, it's coming from the government, but reimbursement is supposed to be quick and easy to obtain. Dollar for dollar tax offset will be provided. And if there's a refund owed, the IRS is going to try and fast track that refund. So this is how the process goes to apply for tax credits, and you need to keep track of your payroll tax liability and costs. So typically FMLA isn't going to be reimbursable. So this is a very different track for employers in that way. There is a small business protection exemption for employers with fewer than 50 employees. You could be eligible for an exemption from both of these types of leave if you can show that the viability of your business is threatened by letting employees take this leave. The guidance on what that standard, what you really have to prove, that guidance is not very clear. If this will shut down your business to let all of your employees take 2 weeks of paid leave or take 12 weeks off, it obviously matters depending on your size, skill set, cross-training abilities. But if you're an employer with 3 people and 2 are gone, that might cause the viability of your business to be threatened. So the guidance is still coming out. There's a potential businesses smaller than 50 employees can try and avoid the application of these 2 acts of leave. Record keeping for EFMLEA is similar to the emergency paid leave. The proof they need to show is the school or childcare has been closed. And so a notice posted, something in the newspaper, something from the website of the children's school would be adequate. And here's the answer to the question that came earlier. The requirement applies to that first weeks of unpaid leave that run concurrently for the same, or they take leave for the same reason. Even if they're saying they have to take those first 10 days and you're not paying them for the first 10 days of leave, they still need to provide proof that the school has been closed, even for that 10-day window where you're not paying them, because your reimbursement, or your EFMLEA won't kick in until day 11 of work that they've missed. And if they haven't proven that the first 10 days the school was closed, then that should delay when you start paying EFMLEA leave for them. Again, retain the employee documentation in your records for when you apply for the tax credits. So that was a lot of information. So I wanted to sort of boil it down. What should you as employers be doing right now? Tomorrow, these acts go into effect, I think, for every single one of you on the call. You need to notify your employees of their rights. The DOL has put out the posters you need to hang up in your workplaces right now, especially those of you who are actively working and have not shut down or closed your business down. Post these either on the internet, intranet that you have, wherever you typically post Department of Labor or OSHA posters. You need to post these. There's two, one for each type of leave. And you can go here to the website to find them. You need to update your policies or create policies if you are now covered by these acts and you haven't been in the past. We've done this for several clients. We're willing to work with Chelsea and talk with each of you individually if you need to get policies crafted and drafted. But if you don't have these in place, you need to get these in place very soon, working with your HR team or yourself if you are the solo HR person. And then you obviously need to create a system to track paid leave for your tax credit applications if you don't have that already in place. So a question came in that if an employee is currently on short-term disability for pregnancy or birth, are they eligible for the paid sick leave? That's a good question. If they're already receiving short-term disability and or FMLA, that I might have to get back to you on. The guidance is coming out on how to deal with very specific situations like that and how folks are treated. The best I could do is tell you that if someone is, a pregnancy is a good example. If someone has already taken maternity leave, they had a baby January 15th and she's taken her maternity leave, she won't have EFMLEA hours to take, but could potentially take the sick leave, the 2 weeks of sick leave pay. So if someone's currently on short-term disability, I would think when the short-term disability runs out, if the person can justify that they're remaining off work due to COVID-19 and one of those 6 eligible reasons, that's what I have a hard time answering. Maybe the childcare would be closed, so that would be reason enough, but maybe after short-term, I don't want to mess up your benefit plan. So after short-term disability expires, they may potentially be available or eligible to take the paid sick leave if one of those 6 eligibility requirements is met, and the daycare being closed would be one. So I don't only practice employment law, and in dealing with the COVID-19 issues, employee issues are not the only issues you're likely facing. I expect that. So I just want to share with you a few other considerations for our businesses and employers to be thinking about with this public health crisis. Review your insurance policies, all kinds. Commercial general liability, employment practices, even workers' compensation. If an employee can actually prove they got COVID-19 at your place of work, that could arguably be a workers' comp claim. Isn't that crazy? So preserve your documentation. You need to give timely notice of any potential claim. And I would say if there is a chance you have a claim, file it timely. If you don't file a notice of a potential claim, you lose that right. So keep track of it, look through your policies and file timely notices, keep track of all of your losses. There is definitely a dispute out there, and one policy or insurer may not have the same answer as another insurer. This is going to be very specific to who bound your insurance, but it's potentially possible that COVID-19 contamination or loss can qualify as a physical damage or an actual loss under your liability policies, and you could claim it. There's past case filings. There's already a case that's been filed against director and officer insurance liability related to the cruise lines, that they didn't act reasonably in their role as director and officers. They should have shut down the cruise sooner. If any of you were on that cruise, I'm sure you'd agree. And so there are some very angry cruise goers that have filed a suit against cruise ships, directors and officers, and it's going to hit that D&O policy. So there's many different types of insurance policies that could be implicated in this crisis. Pull those out, review them, work with your attorneys or risk management office to review those. We're happy to do that with you alongside of you as well. I draft contracts a lot, all day, every day, and we're living a force majeure clause right now. A force majeure clause allows for non-performance of obligations during periods of crisis and act of God. Does your number one customer or supplier contract have a force majeure clause in it that covers pandemics or communicable diseases? Those are going to be things you may have to look at you've never looked at before or talk with your attorneys on. Contracts are going to be canceled, delayed at best, renegotiated. There will be disputes and litigation and demands and lots of things shutting down with the rollout of the economy. And so I just encourage you to pull out your contracts, look through them again, and be prepared to dispute and fight and know what your contracts say and get them enforced. Or if you need to get out of a contract, know what your contract says so that you can invoke a force majeure clause at this point in time. Our law firm, along with every accounting and law firm out there, is hopefully providing updated COVID-19 responses and resources. That's where you'll find these slides. And I know that Chelsea is going to continue to be reaching out and share with you a recording of the webinar, as well as ongoing information. It's changing more. The stimulus package and especially that payroll protection program is going to be very important for some of you. So that's coming and we're staying abreast of all of these updates. So for updated information, find resources that are out there that can help and target your needs and possibilities for keeping your businesses in the black and afloat during this really tough time. I'll let Chelsea talk about office hours. Here's my information. Please feel free to reach out. And I'm more available by email and phone with kids in the background. And I appreciate all of you being on the call today. So we have a little bit more time for questions if you have them. Otherwise, I'll turn it over to you, Chelsea.
Awesome. Thanks, everyone. If you do have questions, go ahead and put them in. Any last minute questions? And then just a couple of updates on our end. We will have another webinar tomorrow at noon, which will be with the Indiana Small Business Development Centers. And we expect to get some additional guidance around the CARES Act and the SBA loans tomorrow when they present. So please tune in for that information tomorrow. If you haven't signed up for a one-on-one meeting with the Generator team yet, you are still invited and welcome to do that. I'll send out the link again in a follow-up email this afternoon. And we have a bunch of office hours, one-on-one meetings available still. So there's plenty of chances throughout the rest of the week if you need one-on-one coaching or advice for you to sign up to participate in that. Other than that, I'll send out the recording, as Karen mentioned, and the slides as well after this. And we look forward to hearing from everybody again tomorrow. Thank you all for logging in.
Thanks a lot.
Thank you.